There are judgments also, my lord, that different they cannot, there's a limitation will not come also, my lord.
Okay.
And next.
Where
my
is
lord,
the assessment order?
No, there is no assessment, my lord. There
Till
is no
now.
assessment.
There is an interim order.
And lordship, the most funniest part is that, my lord, they've taken a plea that is time barred, but no document has been annexed that how it is time barred and what is the reason behind the time barred, my lord. They have taken 3 points, my lord.
Provisions will speak.
Now, if it is found, Mr. Gogoi, that they were not at fault, it is the fault of the the deduction was already made. Although they have to come up before you with that.
Sir, my lord, we have my lord, provisions in
Law.
the VAT Act, admitted.
Okay. Mr. Bora, give me a date. You have already given me a date.
Still fix it on 27.
So there is no application for review of this order. So there has to be something more here.
Fix it on 27th.
Then there will be a cost
What?
because this is an undertaking.
Then also will reduce it to 20.
Any reduction other than today,
No, Lord.
it would be a cost.
I need the Lord will fix me.
No. Today starting.
On 22nd, my lord, in the meantime.
You will not fix it. We don't have time. We will not have a slot on the commencing from 18th. We'll have a slot maybe 29th. So 29th hearing date, yeah.
No difficulty, my lord.
29. Okay. The cost is my component. I'll heard Mr. J. Roy, Learned Senior Counsel, appearing for the petitioner. Learned Senior Counsel, assisted by Mr. A. Goel, Learned Counsel, appearing for the petitioner. Also heard Mr. B. Gogoi, Learned Additional Advocate General, appearing for the respondents number 1, 2, 3, and 4. And Mr. S. Bora, Learned Standing Counsel, Guwahati, GMDA, appearing on behalf of the respondent number 5. On the last date of hearing, that is on 24/7/2025, Mr. Bora, Learned Standing Counsel, GMDA, had undertaken to file the affidavit on or before, was directed to file the affidavit in the matter on or before, his affidavit in the matter on or before 7/8/2025. However, the matter on being listed today, no affidavit has been brought on record by the GMDA authorities. Further, there is no application for a review of the order dated 24/7/2025. Mr. Bora has submitted that he would file the affidavit on behalf of the respondent represented by him on or before 26/8/2025. Also, as the default has already occasioned on the part of the GMD authorities in filing an application, the prayer for adjournment is accepted subject to payment of a cost of 2,500 to the registry of this court. Full stop. The registry on receipt of the said amount shall forward the same to the Assam State Legal Services Authority for its use in its activities. Full stop. The deposit of the amount be made by the respondent number 5 on or before 28/2025. Registry to list this matter again on 2/9/2025.
120. If I fail 126, my lord, that cost can be given.
Cost, nowadays, this is the thing. I'm sorry.
Sorry, my lord. Again, I was told I was not there.
This was. You are for?
Agriculture.
It will leak it also. Art or sericulture. Because we'll have to, I will have dispose it, but we'll have to bring in Sanjita Roy also. So I have kept it. I'll pass the order.
B6.
Yes, Mr. Hazarika.
Your Lordship, my lord, I want to put the documents on record on behalf of the newly implemented.
We have substantially heard the matter. You were supposed to receive certain instructions, Mr. What happened? Have you received those instructions?
In a sense, on a limited point is that
we are guided by the guidelines which has been issued by the Ministry of Environment. So this, it lays down the criteria which are to be followed for stone crushers.
So what are the decision of the Supreme Court in that matter? You're not. There is a decision of the Supreme Court also with regard to stone crushers. Are you following that also? Yes, what is the document you want to bring on record?
Wife and the her.
And what about the distance between the forest reserve and this eco-sensitive zone? That is the issue? Hmm.
For residential area.
Residential area.
Residence.
Okay. What is the document you want to bring?
Wife has been substituted and now. The consent to operate doing as per.
Okay. Let him have his full satisfaction. But this is a 2014 matter we are not giving him. Mr. P. Hazarika, Learned Counsel, appearing for the respondent number
10, 1 and 2 now.
10 bracketed Roman 1 and bracketed Roman 2 submits that he be granted 3 days time to complete 1 week time to bring on record additional documents relevant to the issue arising in the present proceedings. Also, Learned Mr. P. Burwa, A. Burwa, Learned Counsel for the petitioner, expresses urgency in the matter. Also, this court also notices that the matter is pending since 2014 and was heard at length on the last date of listing. However, for the ends of justice, prayer of Mr. P. Hazarika is accepted. Raised to list this matter again on 26th of 26/8/2025. No further adjournment shall be granted in the matter. He wants to have one more. We have heard it substantially. He wants to bring on record 3 documents. From 14, I said, okay, fine. We'll wait till 26. Let him have his full satisfaction. And Mr. Urva, you also.
If needed, I will also produce the records.
Records are required. You will have to.
Maybe reflect.
How you have done it.
Yes.
And Mr. Burwa, make a small note of the arguments of Mr.
Fine.
Marco. And if possible, give it before the next day. I'll not be here on Friday. You can give it by Thursday.
Fine.
If possible, next Thursday, before her head to deem file to move declare. If they do.
May I please your lordship? Your lordship, as per earlier order, the honorable court directed the Water Resource Department to 7 identified petitioners.
Yes. Huh? Why the delay? Second August, you had forwarded this. Why this was not concurred? The petitioners are suffering. Who is there for the finance department? Can you get somebody from the finance department? Get it? We'll pass orders.
We are being led by Dr. Saraf in this matter.
On the prayer of prayer is made on behalf of Mr. A. Saraf for an adjournment in the matter on account of the fact that he is on legs in another case. Prayer is not objected to by the Learned Counsel for the respondents. Raised to list this matter again on 4/9/2025.
4/9, Lordship.
4/9. In between, we are full. 4/9. Aroma.
File your place. Pass over this matter for time being.
Time being not possible today. Many time being is there.
Coming, just he's in port number 3, my lord.
Okay.
Obliged.
Please, your lordship. My lord, for the last order, my lord directed the bank to get certain instructions. Proceed to that, my lord, that filed affidavit.
Hmm. Do you want to file any reply to this?
No, my lord.
Yes. Total 87,000 or. Hmm. Is the hold on the account of the petitioner or the hold is on those two account amounts only?
Particular to one.
Amounts. Does his account, you have further money in the account?
Yes, my lord. My
You're
lord,
operating that
at the
account?
Time of filing of the writ petition, the total balance was 297,829.
Hmm.
The entire amount was freezed. Just yesterday, my lord had come to know that they have put into hold 87,479.
The rest,
My
they are permitting you to operate. Then you
But my
continue.
lord, that 49,000 which they are claiming to freeze, that is pertaining to the same transaction which has already been reverted back. My lord, may kindly have page.
Okay,
one.
now that you are permitted to operate your account, operate it, we'll hear this matter. The learned counsel, Mr. Das, learned, you are appearing for, Mr. Das, you are appearing for? Mr. Das, learned counsel, K. Das, learned counsel appearing for the respondents number 1 to 4. That is, the authorities of the State Bank of India submits on instructions that the hold currently operated with regard to the account of the petitioner, that is account number 10821735461, operated by him, by the petitioner with the Dispur branch.
SBS.
State Bank of India Dispur branch is only on account of two amounts, that is rupees 38,479 and rupees 49,000, totaling 87,479. Also, he further submits that the bank authorities have permitted the petitioner to operate his account as before. However, the petitioner is to maintain a balance in the account of rupees 87,479. Right?
We kept it for only because of that.
Direction from which court?
Mr. First class. I managed the order also.
Also, he further submits that out of the said amount now put on hold in the account of the petitioner, an amount of rupees 38,479 is required to be reverted back to where is that order?
For my lord.
That case, my lord, may I make a small submission? My lord, may kindly come to page 121. My lord, this is a mail which has been sent by the AGM Surveillance and Investigation Department, and there they have requested the Kerala police to confirm as to what is the correct position. And also with regard.
Here is the two transaction, one.
My lord, may kindly come to page
Cut off.
number 123.
Mr. Das, on the next date of listing, shall apprise this court as to whether the amount of rupees 338,479 deposited in the account of the petitioner, which is now treated as to have been so deposited out of crime proceeds, would be required to be refunded. No, it's 49. This is with regard to 49 only.
And also 30 also. my lord.
Where is 38?
123, page 123, the second query, my lord. Court order from judicial magistrate, court number 2, Vasi has mentioned for payment of 49,000 and 38,749, while the disputed amount was only rupees 49,000. Customer has asked for clarification regarding the same. So, my lord, this is the investigation department asking for a clarification.
My lord, he made a mail, my lord.
Okay, okay. On das, on the kya lihi show me? Price. 38,479 deposited in the account of the petitioner, which is now treated to be a deposit so made out of proceeds of crime, has been further clarified by the investigating agencies, and as to whether there is a need existing for the debit of the same, and for debit of the same for being forwarded to the authorities in terms of the communication dated 22/5/2025 issued by the in terms of the communication dated 22/5/2025 issued by the Inspector Crime Walvi WALIV Police Station Walvi Police Station. Full stop. The said instruction be placed on record by Mr. Das on where is that order?
That is order, I have annexed here, my.
No, that is by the order. Then he says that
Sir, B.
there is further clarification sought for by the investigating agency.
My lord, what happened, my lord? I will come, my lord.
Hmm.
Sir B, my lord, page 94, my lord. For a moment. Serial number 1 and 2 is his accounts number. Where that, my lord, that Wallet police station has directed the bank to revert back that amount, my lord.
Okay, okay, cut off. Mr. Let them revert back. They will.
Yes, my lord. 38,000 we are
uh,
bound to revert back, my lord.
If they revert back, if the matter is allowed, they will provide for that. That much I will provide for. You revert, but if he is successful in the matter, you will have to give him that amount.
He made a mail. His mail also I have annexed. He said there.
Okay, we'll hear the matter.
Yes, my lord. That's.
We'll hear the matter, sir. When?
It's convenient to my lord.
Let us have it on 21st. As agreed to by the Learned Council for the parties, registry to list this matter on 21/8/2025 for final here for admission hearing. Also, an endeavor would be made to dispose of the matter on the next date of list. So Ms. Fugon appears for the respondent number. Government CGC appears for the respondent number 9 and 10.
Bless my lord.
Please, Lordship.
Yes.
Well, the challenge made in this writ petition is the order, Lordship, case Lordship 59.
50?
59. This is Lordship, the second round litigation. And earlier round, Lordship, it was directed to dispose of the revision petition filed by the sir. Name is at serial number 3, Patta land measuring 25 biga.
25 bigha. Hmm. Yes, madam, what is your instruction? You were given, you don't appear, you were given of this matter is pending since 13/6 for the purpose of the matter had again come up on 1/8. There was no representation from your end.
There is no reason in the order why the petitioner name has not been considered. Land is still under possession of the petitioner. If your lordship kindly come to one latest report. 1000 page 52.
Just a moment. How are you related to Nitai Chandra Das and Gaur Chandra Das?
They are the son of Shuklal Das, lordship.
And who are you?
Now the grandson, after death of lordship, the Gauri Chandra and Nitai, they are lordship legal heirs. Son,
Where is that material that you are legal here?
yes, lordship. Case lordship 4, para 2. And para lordship 8 also, lordship, I have.
So this land was held to be ceiling surplus land.
Ceiling surplus. 37 bigger land has been made ceiling surplus.
But this was made sometime in 78.
Yes, there's 76 and revision petition was.
78.
Yes,
Where is your
that page 52, your lordship will find the report of the circle officer. Land is still under possession of the
this is the possession.
possession regarding possession description of land and land lordship. Page 28 is the order whereby lordship the land has been made ceiling surplus.
So what is your case with regard to the
24,
declaration of this page 28?
my lord. 37 bigger of land that has been acquired.
Hmm.
Details of the land your lord has been given in the lordship impugn order as
Hmm.
well as the report of the circle
Hmm.
officer. Page 50.
All this land is recorded in the name of Suklal Das.
Yes, initially it was Suklal Das. 1969 lordship, this 25 bigger and 25 bigger, 1 kata, 15 lesser land where lordship mutated in the name of.
Whether that will take it out of the ceiling proceedings.
Yes, that should be, but that has been.
Show me the provision.
My lord. But they were
They-
living separately.
Oh,
Yes,
yes, Mr. Majumdar. What is the law? The man had around 54 bighas of land. So it was, that ceiling act was applied and 37 bighas were taken away. Now, the petitioner's contention is that before that could have happened in 1976, in 1969, 25 bighas of the land was already transferred in what form?
By way of lordship, sale.
Sale deed in the name of the children. Children. Whether that will take it up out of the purview of the ceiling land total. Ah. 50 bighas.
Else, before. Not agree.
But if it is inheritance, that will not take it away. Gift deed, that will not take it away. So show me your sale deed.
But the sale deed is not there, lordship. But
Then
Jamabondi lordship, that is there.
how? How have you got it? There has to be a sale deed, Mr.
Uh.
Otherwise, if it is inheritance, gift deed, then it will be hit.
Sale deed is.
What is your statement with regard to the transfer?
But the details, lordship, I have given, page 5, para 3C.
No, how this land came to be recorded in your name? In the name of your immediate predecessor.
But during 1969,
There has to be some instrument. It was in the name of Suklal Das.
my lord.
From Suklal Das, how it came to Nitai and the other person. Hmm?
Jamabondi lordship, that is your lordship.
And that now that line in the impugned order, the last paragraph, is clear that you had not brought on record any material.
They were whatever, stated that whatever records available in this case are in the case details.
So there is no better material than what you have brought on record here. So where is that Jamabandi copy?
Lordship, page 26, lordship. 26 in second, in the middle, lordship,
Read
number 2.
SDC.
SDC, so and so, Tarikor, so and so,
Sorjamir Amzari.
হুকুম মতে 14 নং দাগর অংশ রেজিস্ট্রি করিদা সূত্র
Registry
12 and lordship in 2 parts is there, 12 bighas some kathas and
Chandra.
another is 12 bighas some kathas. Yes, জমির গৌরচন্দ্র দাস, পিতা শুক্লাল দাস, নামত মুঠ ইমান 25 বিঘা altogether. 12 bighas something and 12 bighas something.
That I've seen.
Prior to that, lordship, up to 1972, ceiling was 75 bighas. After 75, 1972, lordship, it become 50 bighas. After amendment, it became 50 bighas. Earlier, it was 75 bighas.
You are claiming it from through Nitai Das or Gaur Chandra Das?
Nitai and Gaur.
How?
Lordship, both are the son,
No. You are the relative of, you are the daughter, son of whom?
my lord, I have given,
Cephali, Tonoy is Gorsandro.
yes.
Or Cephali also Gorsandro.
Shep-
Krishna and Vasudev, Nitai. 3 and 4 Nitai, 1 and 2 Gaur.
One and two are the wife and son of late Gorsandra.
So here do we find the name of Nitai. But how come this transfer? What is the, you have written registered seal deed in your translated copy. But in the Assamese version, it's not there.
My lord, I think-
Registry.
I think the registry Khurida Hutri, I think lordship, I may be wrong lordship in that, but here short form is used.
Okay, let the instructions come. Where is Mr. Mac? Naturally, he's a busy advocate. He'll be on legs only. But the legs is inside a court or in the corridor? Court, sir. Then it's fine. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. J. Handick, learned standing counsel, Revenue Department, appearing for the respondent number 1 and 2. And Mr. A. Bhattchaji for respondent number 1 and 2. And Mr. J. Handick, learned government advocate, appearing for the other state respondents. Miss A. Bothakur, learned counsel, appearing on behalf of Mr. P. Nayak, learned standing counsel, BTC, submits that she be granted time till 29/8/2025 to complete her instructions in the matter. Also, registry to list this matter again on 1/9/2025. Full stop. On the next date of listing, comma, in the event the instructions are sought for is not placed on record by the, in the instructions is the stand of the respondent are not brought on record by way of filing an affidavit and or receiving a written instruction in the matter, more particularly with regard to the challenge made herein of the order dated 16/12/2024, disposing of the revision petition filed by the petitioners herein, comma, this court would proceed to consider the matter for passing of interim directions. But I'm sorry, it may not be very feasible.
I know.
You try to get some material.
In this case, I was supposed to file an affidavit regarding service. But although I filed affidavit, but my lord, actually it has not been tagged in the record. I made an inquiry, I found that there's defect in the affidavit. So my lord, the defect, I'll file a fresh. One week time, my lord.
Mr. M. Kokoti, learned counsel appearing for the petitioner, submits that an affidavit has already been filed by him after effecting service upon the respondent's number.
We could not affect service on respondent number. Is why.
Why?
Because my lord, actually what the thing is that my lord, he is a habitual offender. So he is basically on the run. That is why postal and all the service could not be. affected.
Mr. M. Kotoki submits that an affidavit has already been filed by him, wherein it has been stated that the service of notice upon the respondent number 2 by way of dusty mode could not be affected inasmuch as the respondent number 2 was not found at his place of residence. Also, the said affidavit was so filed on
1 month ago, my lord.
about a month ago. Full stop. However, he submits that a defect being there in the said affidavit, the same was not tagged with the records of the present case. Mr. Kotogi undertakes to rectify the defect on or before 19/8/2025 8/2025. So accordingly, registered to list these matters again after 3 weeks on a date to be fixed by it, along with the said affidavit filed by the petitioner. Okay. Yes.
In the instructions.
Hmm.
I've provided the copy as well so that
Hmm.
You should have given the copy yesterday. I'm online, my lord.
Oh, no issue, sir. No issue. What do you have to say on this, sir?
My lord, I don't have a copy.
Oh, you don't have a copy?
No, I don't
just
have a
handed
copy.
over a copy to Mr.
Oh.
What-
Mr. Subject to what you finally argue on this matter and what Mr. Mishra says, a little bit difficult to. Anyway, give a copy.
I just handed over a copy.
Mr. KP Pathak, Learned Standing Counsel, APDCL, in terms of the queries raised during the hearing of the matter on the last date of listing, has received his instructions in the matter in the form of have received the clarifications, have received his instructions in the matter in writing. A copy of the instructions so received has been placed on record. Mr. Pathak is directed to furnish a copy of the same to the Learned Counsel assisting Mr. D.K. Mishra, Senior Advocate, appearing for the petitioner in the matter. You just go through it once and then we'll take on record your submissions.
Well,
Also, parties are at liberty to make further submissions in the matter after perusal of the instructions furnished by Mr. Pathak. When would it be convenient? Just
19th,
the
madam.
next week tied up. Thereafter, any day.
My lord. Look, I can take a chance on 25th or 27th because Thursday I have a matter.
27th,
27th, yes,
27th,
27th.
on 27/8/2025. For further hearing.
All right.
So now you mean to say that it is not the cumulative of two, it is only one. Transformer had, you have taken it.
One.
And it was operating at the full optimum level always.
Survey report was not done.
That is one lacuna.
Survey report that is
What we also
Earlier, only 65% they have themselves calculated. But it is
calculated.
the appellate court which says no, calculate it. Of course, that is as per the supply code. Calculate it on the total connected load.
Hmm.
That is now 938. Now it's an admitted position that 938 was distributed equally by the two transformers.
Hmm.
One, it's their own case. One was found all right.
Hmm.
It was recording energy and supplying it to this thing. One was bypassed. So therefore, my lord, the one which is correct, how it has been taken, the learned appellate authority says the possibility of its being used intermittently cannot be ruled out. Now
That is not the case of the APDCL authorities also.
Yes.
Now they have boiled down that it's only qua the second transformer.
No, but
And
then how
the-
the entire 938? Because 50%.
That has to be apportioned, or
Yes.
638 for the transformer which has been bypassed. It has to be apportioned as 638 and the balance to the one operating. This is okay.
Fine.
I say, Your Lordship, that the formula which the appellate authority did, that is completely alien to the supply code. He has come up with a mechanism
Which is not there.
which neither we agree, and I think even the petitioner is now aggrieved with.
Okay, fine.
In that case, my lord, if it is taken 650 total, that is the supply power. It has to be apportioned, my lord, 50% each.
That was
is
the
the
idea why I required this exercise. Got it.
There is one aspect which I'd like to clarify. The total load was 938.
Connected
It
load.
was not 650. It was 930.
Hmm.
638 is the capacity, second transformer which was by.
And what is the capacity of the first transformer?
So then
Equal.
the total capacity is 750.
750, 750 each.
Since 938 cannot be supplied from one transformer, transformers were used. 638 is what they have taken as
We'll see.
the load of the second transformer.
We'll see. Now we have boiled down.
Yes.
You've got the issues on
Another
road.
small point, my lord. On another small point, section 126(5), subsection 5 says that if they are the period can be ascertained, then it will be for that period. If it cannot be ascertained, then it cannot exceed 12 months.
12 months.
They have 13 months, 22 days. These are the 2 points.
That I agree, Your Lordship. That cannot be done.
For my convenience, if you can give, now you have the notes of the
Right.
queries also. If you can give me a small note, even incorporating this, both of you,
My lord.
will be helpful before the next date of listing.
Yeah, we'll do it before that. We'll do it.
Thank you.
All right.
Three round of litigation, civil litigation. One was, my lord, TS.
We had heard this matter at length. And the last orders passed by this court had narrowed down the.
My lord, narrowed down, but the authority, my lord, the commissioner, my lord, decided, my lord, on what basis, lordship, that the land is within the area of Rakshasini Jungle Block Forest area, lordship. There is no, my lord, specific findings, lordship. Only, my lord, the joint verification, my lord, saying that the forest authority and the DC verification, Lordship. That is not sufficient to decide when the civil court has.
That's
decided
why that civil court thing is gone after the orders of this court.
My lord, my lord's, Lat Mandal's report, Lordship. Possession, as regards possession, it is also stated that I have
It's
no
not a
possession.
question of possession only. It's the question of situs of the land also, where it is situated.
Now, the honorable court now is directed to my lord, make de novo inquiry and order, Lordship.
Hmm.
My lord, what is the kindly see, Lordship, direction, Lordship, of this honorable?
Yes, page 70.
Yes, Lordship.
And the impugned decision was not stalled.
My lord, page 70, Lordship.
Para 11.
Start
And
from
read para 10.
Lordship.
Read para 10. That is the
Lordship.
most important thing.
In the two title suits on which the petitioner places heavy reliance, there was no finding as to whether the land claimed by the petitioner is outside the relaxation is reserve forest, and this relevant aspect needs to be taken into account for considering the petitioners for restoration of patta. If the land claimed by the petitioner is within the notified reserve forest, the plea will be heeded by Conservation Act and the 1981 regulation, but if it is not part of the reserve forest, the petitioner's application will have to be dealt with in accordance with the land revenue regulation.
So, Mr. Ahmed,
Yes, Lord.
the civil proceedings, decrees, all those things, this court in para 9 said, para 10 said, will be applicable, provided the land is not within that reserve.
Within the
forest.
area, my lord.
Within
My
the
lord,
reserve.
how the DC decided, Lordship? That
We'll
is-
come to
will
that.
by
We'll
the
come to
court
that.
grant, Lordship.
We'll come to that.
That's
So,
clear.
civil proceedings gone to that extent. Now, para 11.
In the above circumstances, without interfering with the impugned decision of 30/11/2007, Annexure 11A, the matter is remitted back to the Deputy Commissioner Goalpara for a de novo decision on the petitioner's application for recall of the patta cancellation order. But this time, the DC should not only take into account the absence of physical possession of the petitioner over the claimed land, but should also examine whether the land is part of the relaxation reserve forest, which was notified on 23/10/1959 before the matter is finalized.
Hmm.
The Deputy Commissioner will afford due opportunity to the petitioner and the DFO and take note of the provisions of the Conservation Act and the 1891 regulation and their applicability to the subject land. It is ordered accordingly. Now, my lord, the Deputy Commissioner's order at page 32, 72, Lordship. Married, Lordship.
That's just so. Okay. What do you say about this finding?
Yes.
One, two, second para from bottom.
My lord, on field verification, Lord.
Hmm.
On field verification with both parties and revenue officials of Martia Circle on 3/5/2017, it is evident that the land falls within the proposed Rakshasini forest. The petitioner could not identify the land properly. Rather, they put up a signboard there overnight to claim the land to be theirs. The revenue officials also stated that the land is a part of Rakshasini PRF situated in Rakshasini Jangol block village covered by DAG number 2116. Total area of the DAG 2116 is said to be 1433 1 Katha 101.
Fine,
as
no
Graph
problem,
theta.
no problem.
Earlier, as per the
Now, what do you have to say about this conclusion?
My lord, this is based on, my lord, no records, lordship. Just on the basis
Not
of,
on that.
yes.
Not on that. There is a subdivision here. There was a plot of land which you identified. Is it a fact or not? That you put a signboard there in the land which you claim to
That
be
was
yours.
in my possession, lordship. That was in 2006, my lord,
Oho,
the lot number
oho,
also
oho,
verified.
oho.
Yes.
You have put your, what do you call that, signboard over your land. Is it a fact or not?
Yes, lordship.
Fact.
Yes.
Okay. Now demonstrate. That land is now identified by you, that this is the land which is mine.
That was, my lord, in the village Bolodmari. My lord, subsequently that area, my lord, was
Okay,
renamed,
that is also dealt with. That
Yes.
is also dealt with by the deputy commissioner.
Yes, lord.
That your contention that your land was covered by Tojibahi revenue receipt, particular DAG number in Bodalmari. Bolotmari. That Bolotmari subsequently became Rakshani Reserve Forest. Now, this fact, they say, is not there in the records of the district authorities. That Bolotmari became Rakshani subsequently. Now, I'm not on that. Simple query. You have identified a particular plot of land. Now, whether this plot of land falls within the notified area of Rakshani Reserve Forest or outside that, where is your statement to that effect?
My lord, and this, my lord, that is the answer of the civil court, lordship. Kindly see page 37.
Civil court is gone, Mr.
My lord, as regards
Civil
actual-
court is gone.
What is,
Civil
what is
court
the
is
finding of the land?
Oho, civil court is gone with regard to the forest issue. This court's order has attained finality.
Now,
We'll
what I'm-
not go back. We'll not go back to the. You should have challenged that order. You have not done it. Just show me from your pleadings. Every forest declared reserve forest will have a notified boundary. It cannot be in air. There will be a definite notified boundary.
My lord, where is that? As per, my lord.
Where is that? You show me your statement. You show me your statement that the land which is there in the penultimate paragraph of page 72 falls outside the. Your land is somewhere else. That is the claim made by the petition, the 73 second paragraph.
My lord, page 72nd, yes. It is stated by the deputy commissioner. Where is my
Yeah,
land?
you show me the material to.
It is. it is
Mr.
written
Ahmed,
that-
show me the material to show Bolotmari became Rakshani. Show me. I'm here.
My lord, in the civil code, my lord, honorable.
Forget
court, my lord,
civil
in
court,
earlier what I'm
Forget
submitting-
civil court.
My lord,
Forget.
what I'm submitting, my lord, as regards, my lord, as regards the point whether that plot falls within the forest area or not, lordship.
I'm not on
To
that.
determine that point, my lord, the case was, my lord.
I know that. Now show me that Bolotmari area is not covered by the forest notification of Rakshani, this one, reserve forest. Two, that it is the same land which you claim to be in Bolotmari, which is now where you have put your signboard.
In my land, lordship.
So this land where you have put your signboard, according to you, is Bolotmari.
Yes, lordship. It was
Right.
renamed.
Show me that Bolotmari was brought within the purview of the reserve forest notification. Bas.
I have stated, my lord, that
Where?
Bolotmari is renamed as, my lord.
No, it cannot be. You show me the material to show that it is renamed.
The official record, I have no,
Mr. Council,
yes.
there is a map. The coordinates are given in a forest. When a reserve forest is declared, it is given. The villages which have been brought under its purview, that is also mentioned. Now, if Bolotmari is there, fine, we will
I am
examine.
submitting as regards that, my lord. Where is that map, lordship? On the basis of what, my lord, it is decided that
It is
this
for-
area has fallen in the, my lord, forest
Mr.
area.
Council,
lordship.
that is for you to allege. You have not even alleged. Have you alleged that?
It
Have
is-
you alleged that?
It is, my lord, averring, apart by the, my lord, forest department that.
Now,
the
show me your
area fallen-
statement. Show me your statements in the writ petition to the effect
Yes.
that this land is outside the purview of reserve forest.
My lord, paragraph 4, my lord, I have stated, lordship. During the settlement officer, operation, lordship. During the settlement officer 1960-61, the aforesaid land was wrongly recorded as Khash and marched into Dag number 16. Name was the name.
Where? Tara?
Para 4. That during the settlement operation of 1960-61, the aforesaid land was recorded as Khas and marched into Dag number 16. The name of village Bolotmari has subsequently been changed to Rakshasani Jangal block due to disturbance by the DFO Gwalwara in petitioner's peaceful possession. The petitioner filed a title suit, declaration right title interested possession of the permanent injunction in respect of the aforesaid plot of land against the state Assam and DFO Gwalwara before Learned Civil Junior Division. The aforesaid case was registered, my lord. This is as regards, my lord. My lord, it is stated, is it wrongly, my lord?
Show me the finding of the trial court. That
Yes, lord.
this is, but
In my
that
case, lord.
decision is of no use.
In my, kindly see, my lord, at says additional evidence plus 80.
Page 80.
80, my lord. My lord, it is also answered, my lord, in the title suit filed by the, my lord, DFO, lordship. That is at page 28, lordship. Everything has been decided, lordship.
Show me
Discussed.
that exact finding.
Yes, page 28. 24, lordship. Title suit number 12 of 99, lordship.
But there
I
is no
think the-
execution of that.
Execution was there, lordship. In the this judgment, it is stated, lordship. Execution is there. I am coming to that, lordship. My lord, according to, my lord, may I read, lord, this judgment, lordship?
Just a moment, give me 5 minutes.
In page 26, lordship, execution case number 08 of 95, stated, lordship, in this judgment. Page 26, second para, lordship.
Just a moment. Where is the schedule, land schedule here? Can I find that, the land schedule, anyway you can find schedule of the land?
In my judgment, Lordship, judgment in my favor, Lordship, is 80 of the, my lord, additional affidavit, Lordship. Judgment, Lordship. Decree itself of the here, Lordship.
Degree is at page 22.
Yes, Lordship. He Gwalpara Moza Bolotmari.
And where is the,
My land, Lordship.
okay, and where is the description of the land in the DFOs?
Purpose, Lordship, this is just a judgment, Lordship.
Where is that schedule here?
Judgment, Lordship, schedule is. Judgment schedule is not.
Yes, Mr. Hendick. There were two suits. And both the suits resulted in the favor of the petitioner here or his forefather. Now, both the land involved, is it the same or different in the suits? Because the finding of the trial court in your DFO's matter is that land is same. Then who is appearing for the forest department? Forest is a party here. Mr. Ahmed, forest is a party here.
Yes, Lordship. Yes, Lordship.
Can you get somebody, Gogoi or Mr. Can you get somebody? No. Mr. Ahmed, we'll take it up after some time. Yes, Mr.
Petition is highlighted stage when there was a move to take over petitioner's land cover by PLA case number 1206, violating all the mandatory requirements of Land Acquisition Act. Like the earlier acquisition in respect of 5 other PLA cases, my lord, there is a specific pleadings in the, it is pleaded case of the petitioner that all the mandatory requirements of law were violated while acquiring various strips of land. Now, means the honorable court has passed various orders, my lord, directing the government to file, bring on record the documents. These are the few orders, my lord.
An award has been passed here.
What is?
So you are seeking an enhancement of that.
No, my prayer is that since all the mandatory requirements of law having been violated, because even the awards have been made ex parte during the pendency, my lord. During the pendency of the writ petition in respect of at least in 3 cases, in 4 cases, the award has been passed without giving any notice as required under section 9 and 11.
But here we only have one matter.
Yes, in this case itself, there are 6 PLA cases. Because
Oh, single case, there are 6.
6 PLA cases, my lord, in all these cases, since everything was done behind the back of the petitioner, even from their affidavit, it will be evident, my lord. Even the notification, declaration, notice under 5A, nothing was followed, my lord.
This is under the earlier act.
They admit
This is under the earlier act.
earlier act. And the admission is there in their affidavit, my lord. Your lordship may
The
kindly-
land has been taken over.
Yes, sir. But in respect of one case, my lord, your lordship may kindly take up the orders, my lord, dated 10/4/13. These are the type copies of the orders. 10/4/13, my lord. The respondent number 2 shall in the meantime furnish the copies of the award passed in PLA cases number such and such. Because an impression was given to the petitioner that awards have already been passed. So the honorable court was also of the view that the copies of the awards should be provided so that petitioner can prefer references under section 18. Now your lordship may kindly see the order dated 31/5/13. PL Singh to obtain instruction as to whether the notice in the newspaper had been published and also whether the substance of the notification was published in the newspaper. C may also ascertain as to whether the petitioner was given opportunity of hearing under section 5 and notice under section before assessment of complaints, because these are the mandatory requirements. Notification under section 4 is required to be published in the Gazette in 2 newspapers, and the substance thereof is required to be circulated in the locality, and a copy thereof is required to be served on the person interested. This is the requirement, and in a catena of decision, this has been held, my lord. Now, your lordship may kindly turn to their affidavit. Your lordship will find from their affidavit itself. Page number 59, my lord. Running page 59, my lord. Paragraph 9. Running page 59.
Affidavit
internal
to
page
Belekki
2,
Assembly.
their affidavit in. This is their affidavit in opposition, my lord.
Affidavit by
By revenue respondent number 2, my lord.
on
This is filed on 22/5/13.
uh, 22/5/13.
Running page would be 59 and internal page would be 2. Paragraph 9, my lord. That as regard para 9 of the writ petition, the deponent begged to submit that notification issued under section 4 of the LA Act and declaration under section 6A are published in
It's
the.
called Petroleum and Mineral Oil Exploration Act, that act,
It is another, my lord. The
PMLA,
PMLA Act is laying of pipeline, right?
pipeline. What is that act full name?
It is, my lord, right to petroleum and mineral pipeline,
Something like that,
laying
no?
of pipeline, Act, my lord, 1961 or 62.
Is it there?
This is not in when a PLA Act, PMA Act is not applicable in this case because this is a permanent acquisition.
Okay.
In that case, my lord, only under that act, my lord, the right of,
Surface,
right of user is
surface.
only surface, right of user is.
Okay. Yeah, this is permanent acquisition
Permanent
under the Land Acquisition
land
Act.
acquisition. That as regards para 9 of the writ petition, the deponent begged to submit that notification issued under section 4 of the LA Act and declaration under section 6A of the LA Act are published in the official gazette for information to the interested person, general public.
LA Act Purana to divorce.
The owner of the land cannot claim the service of the same by the collector. Further, as the original notification declaration are with the revenue department, the owner can approach the appropriate authority. The matter has been informed to Diganto Bora, learned advocate who applied for the document. So, my lord, even after making an application to supply the copies of the declaration, those have not been furnished. So, everything was done behind the back, my lord. Now, you also may kindly come to page 63.
para 15.
Internal page 6 will. That as regards para 20, the paragraph 25 below. The deponent begs to state that as per provision of elect, notification was published in the offices. So their only statement is that the notification in paragraph 27, the declaration was published in the Gazette. So the requirement to publish in 2 newspapers and
Not-
to get the same circulated in the locality, that was not done, my lord. Now your lordship may kindly come to their another affidavit. Running page 87.
Just now.
This will be flex C, additional affidavit dated 3/12/13, my lord.
When was this notifications issued?
My lord, I have
Gazette,
given a-
Gazette,
I-
Gazette,
I
Gazette.
have given a chart. The chart, your lordship will find the dates of notification and the relevant pages where the same are available.
9/5/13.
In PLA case number 10 of 2004, it was 9/5/13, and this is available at page 115.
Okay.
The documents which were annexed by them, I have given the page numbers, my lord, in this chart in respect of various PLA cases. My lord. Now, as far as 12 of 06, PLA case number 12 of 06 is concerned, my lord, they have already abandoned the acquisition proceeding, which was,
That is not included here.
that is not included here. Your lordship may kindly come to their additional affidavit dated 3/12/13, my lord,
Filed by
respondent number 2.
3/12.
13. This is flex C, my lord.
Huh.
Your lordship may kindly come to page 87.
Internal page 2.
Subpara of paragraph 3, my lord. On 16/8/2013, Honorable Court was pleased to direct the collector to file affidavit enclosing there to the publication of notification as required under section such and such, and also compliance of the provision of section 5A and section 9 of the said act in respect of PLA case number such and such. So this is the direction, and in compliance to that, this affidavit in opposition is filed, my lord. Additional affidavit is filed. Now, your lordship may kindly come to page 89.
Further,
Further, it is humbly submitted that as per Gazette notification dated such and such, it was specifically mentioned that in exercise of the power conferred by section 17(4) of the Act, government have decided that in view of the urgency of the project, provision of section 5A of the Act shall not apply to waste or arable, hence provision of section were not applicable in the instant case. So this is the admitted position that section 5A notice was not issued and the opportunity was not given. I have supplied to your lord, so I will refer to those judgments, my lord. Even if 17(4) is invoked, the requirement to give opportunity of hearing is a must, my lord. Now, your lordship may kindly turn to next page.
just now. Where is the declaration under section 6 that 5A will not apply?
That your lordship will find from the notification issued under section 4.
Ah.
Those are
There is a,
at page 115, 128. I have given in the chart, my lord. Your lordship may kindly take column 3.
Gazette notification.
Yes. This is given
115.
115 in respect of PLA case number 10 of 04. This notification is made under the provisions of section 4 of the Act as amended by such and such. Last para, in exercise of the power conferred by section 17(4) of the Act, government have decided that in view of the urgency of the project.
5A will not apply.
Similar notifications were issued in respect of other accusation cases also. Page number I have given, my lord. Now, your lordship may kindly take up page 90. 90.
So the hearing has been done away with.
Done away with.
But you say that initial 4 has to be satisfied. That cannot be done away with.
Even this section 4 cannot be done away with. Section 5 is to be complied with. 5A. Then
There was
section,
a decision, right? Just
Lord, I have given the booklet. I will.
wherein the
Let me
Supreme
cite.
Court has said that in the event the provisions of notice is not complied with, the entire acquisition proceeding goes.
Yes, my lord. I have given those judgments, my lord. I will refer to those judgments, my lord. JK Housing is there, my lord. Your lordship may kindly first take up page 90.
90, yeah.
Regarding section 9
Hmm.
of Land Acquisition Act, the preliminary LA formality like joint spot verification on land measurement and demarcation, including assessment of zerath of the land, were jointly completed with the representative of the Tea Garden Authority, which covers the LA formalities under section 8 and 9 of the LA. During spot verification measurements and also at the time of enumeration of zerath, the R&T plantation Lakwa did not raise any objection and duly signed in the assessment lien towards payment of compensation. Now, my lord, what has happened, my lord? When you are acquiring the garden land, you have to make a zerath enumeration list in respect of the standing crops. So this is only in respect of the zerath. The documents your lords will find at annexure 12 onwards. These are only in respect of the how much of number of tea bushes will be uprooted, how much is said tree will be uprooted. This is only the calculation.
But
Compensation is not determined in those. The requirement under section 9, read with section 17(1) is that you cannot take over the possession of the land unless and until a notice under section 9 is issued, which requires the inviting claims and objections.
now what is your relief that you're seeking?
My contention is since in all the
Everything will-
provisions have been violated, so the award has to be set aside and they may be directed to
In the 2013 Act.
13 after giving fresh opportunity to it. And those are the judgments, my lord. I will take your lordship to those judgments, my lord.
But Mr. Kejriwal, little that I know about this is under your
The
guidance.
judgment is there because
No. Little which I have known about this acquisition matters is with my association with you on this issue. So one thing you just tell me. Why did you permit the zerath to be calculated? If you are not, if you are saying that the no notices were given, the whole proceeding is bad, why did you participate in the zerath calculation?
involves exploration of oil and gas, my lord.
So you,
I cannot avoid, my lord.
Okay. That means with regard to the accusation, you have got nothing to say.
Yes, my lord.
You have got nothing to say. Accusation is perfect. Zerath calculation, perfect. Then it will boil down to the amount of compensation given.
For that, you have to invite.
Now. Forget everything. Either the process is wrong, so everything is wrong. But if you have accused to that process by being a part of the zerath examination, that means you knew at that point of time of this proceedings being launched, but you did not protest. So that proceeding, to that extent, whatever lacunas are there, gone. You have accepted. Now the question is compensation. Go before the reference court.
Of approaching reference court will arise only if the provisions contained under section 9 and 11 are complied with and a valid award is made. And for making a valid award, the
How is 8 and 9 violated?
section 9 and 11, your lordship may kindly see.
Yes.
First, your lordship may kindly take up section 17, because the notifications were issued under section 17(4).
Just a moment. Now, Jirat, the estimation of Jirat will be made prior to 9 notification or after 9 notification?
Prior. Because,
After the Jirat calculation, only the 9 will come into
yes,
being.
my lord, because since you are acquiring the land by invoking urgency provision under section 17(4),
Hmm.
so you have to prepare the enumeration list. You have to make an estimate. You have to pay 80% as per section 17(3)(a). You cannot do that without complying with the provision of section 17. Your lordship may kindly first come to section 17.
Okay. 17(4). Special powers.
Special power. In case of urgency, whenever the appropriate government so directs, the collector, though no such award has been made, may on the expiration of 15 days from the publication of the notice mentioned in section 9 subsection take possession of any land needed for a public purpose. Such land shall thereupon vest absolutely in the government, free from all encumbrance. Now, your lordship may kindly take up subsection 3.
In every case.
In every case under either of the preceding subsections, the collector shall at any time, at the time of taking possession, offer to the person interested compensation for the standing crops and trees on such land and for any other damages sustained by them caused by such sudden disposition and not accepted in section 24. Now,
Now here, this Zirat is after 17(3). Okay. So first 9(1) notice will go.
Yes, my lord, that notice.
15 days. 15 days. Then the.
And they will make assessment.
No, no. Then they will issue a notification under 17(1). 15 days from 9(1). 17(1) will come in. And if 17(1) comes in, then thereafter 17(3) would come. Zirat compensation, Zirat and all will be determined. Now, your determination of Zirat, where you were a part, is it 17(3) or the one prior to?
Prior to date. Because for the Milord, for the purpose of
Mr. Kejriwal, some doubt. When is this Zirat calculated? This happens to be within the, after the 70, what was the date of this joint verification? (11) and 12.
your lords may kindly come to annexure 12.
And 17(4) notification is of?
This is in respect of, as per order of PLA case number 12 of 2006, my lord. This is in respect of the PLA case which is already withdrawn, my lord.
Okay.
They have annexed these documents only in respect of one PLA. Now, whether the Jirat were carried out in respect of others, I am in dark, my lord.
Because you have amalgamated
5-6 cases. Total
5-6 cases together.
6 cases.
So individually, what is the material to show, as per you, that yes, this Zirat was assessed on so and so date, thereafter 80% of compensation was paid?
Their document itself will show, my lord. Your lords may kindly see page 66. This is the affidavit in opposition, my lord, page 66.
And these are the dates.
Dates are given, my lord. Only in respect of first two cases, 80% were paid, my lord. Balance were paid subsequently, my lord. But in respect of all others, even the possession was not taken over.
So one the part under B, this is still with you. PLA 10 onwards, below. PLA 10 and below. This is with you still.
Subsequently, they have taken over. Some were taken over. So I cannot stop, my lord. This is
National interest. Okay. Just getting the feel. Yes, Mr. Majumdar. What is your stand?
Tendency of the writ 12 years. Thereafter, present status is like cases formed that with the
12. PML at 12.
12, with the money was compensation sector, but they have not received that.
That is gone. Other 5?
Other 5 minor in 4 award was passed before the
Possession taken over.
yes possession in respect of the 5 cases taken by the collector and handed over to
Before 2013 or after 2013? All. Possession in all cases taken before 2013. Okay.
determined after
14.
13
13.
or 14.
14.
14. So, in fact, on the that case, you will have to my lord, as my learned that the Jiraat was not taken into part. Then
That's the first thing I asked Mr. Kejriwal. Now, Mr. Kejriwal wants to reach the 2013 Act. So, by claiming for going for enhanced compensation, he's not going to get 2013 Act. For that, he will have to demolish your 1894 acts that you have taken. So now his case is that Section 4 notification was not issued in the manner it should be issued. It was only in the Gazette. It was not published in the newspapers, and an abstract was not given to the circulated in the area of the or the person concerned. He then comes to Section 9 action, Jiraat compensation. So now I ask the question that if you have accepted this part, if you have participated in this part, so things prior to that gets obliterated. That means you have given. He agrees to that. Till that extent, he agrees. But his case is, you have exercised power under Section 17. If you have exercised power under Section 17, that can be only through a proper notice under 9(1), 15 days, then the possession can be taken. He says that Section 9 notification is absent. What is your answer to that? If that Section 9 part can be established by you. Rest we can take care. No, no.
I'm coming there.
uh,
Stage when the entire amount of compensation questioning the, yes, possibly will not happen.
we are not with him. We are not with him with regard to the section 4 application. We are not with him. Section 4, we will say it was done because he has accused to her. I just want a clarification because there are decisions of the Supreme Court wherein the Supreme Court has said section 5, section 4, 5. I don't know about 9, I've not come across, but 4 and 5, if the notice is not issued in the manner required, the entire process goes. So if he is successful in that, he comes to 2013 Act because you are already saddled with the responsibility of the land already. So it will be a paperwork only in 2013, so it will be enhanced. So kindly make your submissions on 17 and 19. Then if you can put it in perspective, slight aberrations here and there, given the urgency, no, we may ignore. But the substantial portion has to be satisfied. And by the time the judgments are there, I'll also upgrade myself.
Now, what has happened, my lord?
At this stage.
That was directed to be taken over. Your lords may kindly peruse the order. dated 25/3.
IA bill number 2
I think it had come up before me also.
Yes, yes.
Yes. I heard you also.
Yes.
This is the matter. I see.
Here, the
Previously, I
here-
filed one I-8 721, my lord.
Hmm.
And your lordship were of the view that the documents which were brought on record by respondent revenue department should also be brought on record by me. Accordingly, I filed the subsequent IA 2852, my lord. And the Honorable Court of Bhide order dated was of the view that
So this is closed. That the court said we'll consider
everything, yes.
that we are not going into.
Yes.
We're only.
I'm one of
Hmm. Yes.
page 51, my lord. This
Ah.
is the amendments ought to be made in prayer of the writ petition. Award dated 18/1. Dated 3/5/2010. 10 of 2004. Legal. And in complete defiance of this 4, 5A, 6. Then contention is there has been a violation of section 15. Let there, or at least orally, my lord, so that I can respond. General allegations in
That's true. So, Mr.
same
Kejriwal,
specific question. I'll
your
try to
case
settle.
is violation of 17 and 9. Anything beyond that?
As well as 11, because inquiry is required to be conducted before passing the award. That is the
Okay.
requirement under section
Okay.
11(1).
Now tell me, when was this that Zirat thing?
The
Done.
award is in respect of 3
I'll
cases.
come to
where
the award.
are-
I'll come to the award. But when was this calculation or this verification made? That Zirat in your tea garden, when was there a joint verification you and the authorities undertook that? Which date?
Your lordship will find from one document. I will place one document, 101, your lordship may kindly take.
Page 101.
That the lands were taken over without notifying us, my lord. Your lordship may kindly take page 101.
Okay, okay, accepted, that also. That means after that
And
also
they are
you
doing
participated?
everything ex parte, my lord.
No, no,
They
after
are
that,
making
so you mean to say that the Zirat thing was done after
only in
the,
respect of one matter that has been annexed, my lord.
no, you will know.
That the
Or
proposed,
is it your stand that the Zirat was not calculated in the other cases?
in fact, I'm in dark, my lord. Even my party has not furnished any documents, my lord. Everything was, that is why he asked for copies of everything, all the proceedings. Even the prayer is there in the main writ petition to supply copies of all the proceedings.
Okay, where is your statement that the Zirat is permissible under the old act also? Mr. Kejriwal, Zirat is permissible under the old act. Where is your statement in the writ petition that the compensation that was given to you pertain only to the land, not to Zirat?
The
Because
statement you lords will find at page 10, paragraph 10, my lord. Since the petitioner was under the impression that the ex parte awards have been made, so this statement is made that as far as land covered by serial number 135 of the aforesaid table is concerned,
what is the date of the ex parte awards? This is a para 8.
your lordship will find in the chart, my lord.
Yes.
Serial number 14, my lord. These are the dates, my lord. In respect of 10 of 04, this is on 30/12, 13 minutes during the pendency, my lord. So at least they should have, when this case was going on, and our contention was that no opportunity was given, no notice was given to at the time of making assessment of compensation.
So
This was
the case that Mr. Majumdar was pointing out is PLA 8 of 2017, wherein the award is of 13/3/2014.
14.
Is it one of the award is available at page 248?
Yes,
Okay.
this is 248 of their additional affidavit, my lord.
So amount allowed for trees, houses or other number 251. Zirat has been provided for.
In this case, my lord, your lordship may kindly see even the copy of the award is not complete, my lord. Your lordship may kindly see page 251. Amount allowed for trees, houses, or any other removable properties, 1,02,391. Now, how much tree bushes were involved? What is the assessment, at what rate?
No, that assessment was made with you. You joint verification was made, and thereafter this had come. I just want to get the facts in the written.
In that
We'll
regard,
come to the legal challenge.
I will take instruction as regards whether this Jirat enumeration was conducted in presence of the petitioner.
Petition or not.
That instruction I will-
That one
that I will
statement I
apply.
regret. That one statement.
Even otherwise, my lord, as per the Honorable Apex Court judgment, the notice issued under section 12(2) must carry with it the details of the award. Unless the award is furnished, the petitioner will not be in a position to seek any reference, because the object.
No, I'm only on one point. If the proceeding is so badly vitiated, then we'll be left with no other alternative but to following the Supreme Court judgments to interfere. But if we find that the proceeding had proceeded in the manner required and you had also accused and thereafter maybe you did not go for the award or something, then barring that one case where we'll hear Mr. Majumdar, the other cases, the only remedy would be to go for enhancement. Other cases. In the PLA 8, maybe the state has to redo the thing in terms of this. But for that, we'll have to be satisfied that the just a violation and thereafter you participating, accepting, maybe we will be a little bit skeptic. But when? Kundina Divapari. Mr. Majumdar, when is the suitcases not to be packed? That should be understood in monetary terms, not in cloth terms. The court is taking time, don't worry. I got a hang of the matter now, I'll go through it. I'll forget. 9? So, heard the learned counsel for the parties at length. Course of hearing remains inconclusive. Raised it to list this matter again on 9/9/2025 for further hearing. It will. No problem. 11. It will be better. I'll have 3 days. 11/9/2025
For further hearing.
for further hearing.
Public.
So in the meantime,
Kindly. But Mr. Majumdar, if you can show, because this is basically the petitioner trying to reach the 2013 Act. If he is legally permissible to reach the 2013 Act, we cannot stop him. So you will have to show at which stage, if 9 is not there, if there is a accusance on the part of the petitioner in participating in the Jirat calculation. So those factors maybe we can look into. Kindly give us that. It's here. It will be remain different. It buys.
My pleasure, Lordship, my lord.
What is the stage of the constructions now? Over.
Question is, my lord, how the construction was made, my lord, how the work was executed, how the fund was, my lord, utilized. But there
So you
is
mean
a-
to say that the funds were not utilized in the manner required?
Yes, there is a
There was bungling of money, corruption. Everything was involved there.
On the other hand, my lord, who are they, private respondents 10 to 16, who are they to take a decision to exclude me on benefit of that particular, my lord?
Jurisdiction also comes in
Yes.
of the work.
Therefore,
Why
my
a
lord-
criminal proceeding was not instituted?
My lord, therefore, my lord,
No, why a criminal proceeding was not? Because the persons are private respondents, private
Private-
person. Why a criminal proceeding if this is the material you had? Why a criminal proceeding against 10 to 16 along with the officials involved not
we
instituted?
approached the police station, we lost affair, my lord, nothing happened.
Where is that FIR? Where is that FIR?
As my lord made a statement. we
Where is
approved-
that? What is the contention in that FIR? If the FIR was not taken forward, why it was not taken up with the SP?
Affair, possibly, my lord, we didn't enclose the affair, but we-
Where is your statement with regard to the FIR? And the police case number?
affair was, my lord, case was not registered. But we made representation, we approved the municipality.
So you have not done anything. What is your allegation against the
My allegation,
authorities?
my allegation is that, my lord, once there is a, my lord, prescribed procedure, and deputy commissioner is the appropriate authority under the scheme to receive the money, and he is to, my lord, execute the work by inviting tenders, by engaging the, my lord, appropriate contractor.
Hmm.
Nothing was, my lord, done. And initially, my lord, we approached the, my lord,
Is it in connection with the works undertaken by Guwahati Municipal Corporation?
my lord, they filed an affidavit.
They say no fund was
Yes,
received.
Lord, no fund, we didn't receive any fund, we didn't have any, my lord, control over this particular work.
Hmm.
And deputy commissioner also, number of occasions, my lord, court was pleased to direct the government advocate, at least to, my lord, place on record what is the stand of the deputy commissioner, nothing, my lord. So, my lord, whether lordship is not otherwise inclined, my alternative suggestion would be that, my lord, since we are excluded, can, my lord, can it be possible, direct the municipality to allow us to connect our outlet with the public drain? And if the municipality, my lord, is not in a position to bear the cost, then we are ready to bear the cost. Connect our outlet, my lord, with the public drain at our cost, by, my lord, drawing under.
If you, yes, Ms. Bora. That is not a pleading, that is not a prayer here. We are not, he says he has a house. There is a drain passing by. Whether the outlet from the house can be given to the drain. No. 79, huh? Where is petition number 1? Near petition number 1, there is no drain. Page 79, Mr. Purkhasto. We can come to page 79.
Their affidavit, I think.
Hmm.
But some solution has to be made, but some.
No, that is not your prayer here.
In the
That
writ
is not your prayer
in the writ petition.
in the writ petition.
Lordship is, my lord, well competent to mold the, my lord, relief.
Why should I mold that it will break? I can mold within the permissible limits. You have not even asked.
Then Lord shall decide the matter, my lord. Can decide the matter.
I'll decide.
So whether it is permissible for the private party, my lord, to take a decision to exclude us. And what is the stand of the private respondent? We did not donate 1.5 feet. Therefore, my lord, we are not entitled.
Take your seat, Mr. Burkhasto. Just take your seat. Yes, Mr. Bora. Mr. Bora, I'll give you a role now. I'll give you a role. Don't worry. The drains in the state, in the city of, where is this situated, Mr. Burkhasto?
My lord,
Where is this Guwahati?
what is
Guwahati.
What is
The drains in the city of Guwahati, who manages? So these drains, it will be under the PWD or is it orphaned? The drains in the city, if somebody is making drains and no authority knows about it, can it be? Okay. So Deputy Commissioner has sanctioned this project? This is PM, this is the MP fund. MP fund. Okay. Yes. Mr. Roy, how was the scheme No instruction today. 15 matter. Now I want to think how the schemes were implemented. Mr. Purkhaisto is intelligent. He will not give you many details. He wants the details from you. But he has said one thing here, that these were being done by the private respondents without any governmental interference. Hmm? Who is appearing for 10 to 15 and 16? How did you do this work?
But we have not done it. We have sacrificed our for the construction of the White Top Road.
Okay.
It
The
is-
money you have contributed on your own.
We have not contributed anything.
Then how does
We
this?
have contributed simply our plot of land. All the northern side people,
Oh, you are a resident of that area.
I am on the northern side. The petitioners are on the southern side.
Ah.
And on the southern side, the petitioner, they do not want any drain.
Okay.
They want to connect their
So
disposal.
page 79, this is the. Now who constructed this drain?
Drain is constructed by the government.
Which agency?
It is as per the writ petition, it is from the.
No, it's a drain constructed on the land donated by you.
Yes, we have.
So who has constructed this?
This drain is constructed by the GMC and GMDA at the supervision of the deputy commissioners.
Okay. GMC says it has not done. GMDA also not done. Then,
Then, my lord, it is the deputy commissioner is to
okay,
make
get it.
statement.
2 o'clock. 2 o'clock. 2 o'clock. 2 o'clock. That's the only issue, mister. That is the only issue.
Because
Mr. Purkhaisto, that's the only issue.
That's right, my lord. Lordship is to fix the library because it is not an isolated, my lord, subject.
We'll see.
Every year, my lord, fund is coming.
We'll see. We'll see. We'll see.
So take care of
My
the.
lord, let it be on. Let it be on.
Why was the affidavit not filed? Mr. S.S. Roy, Learned Counsel for the appearing for the Deputy Commissioner, Kamrup. Kamrup Metro submits that he will complete his instructions on or before 19/8/2025 and apprise this court as to the manner in which the constructions involved in the present proceedings were so done and also the manner in which it was so funded. Full stop. This matter is pending since 2015. However, the Deputy Commissioner has not filed an affidavit in herein. Full stop. Basing on the prayer made by Mr. S.S. Roy, Learned Government Advocate, this court permits the Deputy Commissioner a last opportunity to place on record his stand, either in the form of a either in the form of an affidavit and or a written instruction covering all the issues raised in the present writ petition. Also, the said instructions shall invariably be placed before this court in the form indicated above. Set stand shall be placed before this court in the manner indicated above on the next date of listing. Registry to list this matter again on 29/8/2025. On 2/9/2025.
Sir, 2/9 will out of station.
29. Or 4th you are here.
3/4 I'll be out of station.
Oh, 2 you are here.
2 I'll be on the way.
You have
Can
not
fix the
told-
matter? On 29th.
Second you are here, Mr. Purkhaisto.
No, my lord, 2, 3, 4, I will be out of station.
Suitcase packing.
29th?
29. Mr. Roy, get it.
28, I have another case.
28 will not be. Next would be 9th.
9.
9. 9. 9.
9.
9.
9.
9.
I'm grateful.
9 going in. Yeah.
I'm grateful, doctor.
Mr. Muzumdar, give him a copy of a writ petition. He'll give you. Yes, Mr.
Lordship, against the assessment orders passed by the
Where is your response? Yes, Mr. Borua. But today may not be possible. We have tied up.
all issue, Lordship, without jurisdiction and violation.
No, we have got it. Mr. Chaudhary, you have not filed an affidavit also here. Anyway, not required.
Five 530 first.
Yes, what is your case? 6-5? Okay. What is your case?
Lordship is against the impugned assessment orders. As annexure 4 and 5. Before that, I'll take a Lordship to annexure 1, page 15. Your Lordship, the SOCO's notice was issued in respect of the period 2006-7. I'll just read it's a small sort. Whereas it is seen from the case records that out of stock transfer of goods made by you amounting rupees so and so, undue exemption avail for rupees so and so under section 6 of CST Act, read with section 12, rule 12(5) of the CST rule. Hence, you are liable to tax amounting rupees so and so and interest so and so for the period 2006-7. For the period 6-7, this SOCO's notice is in. Then Lordship may further likewise on the total stock transfer of goods for rupees so and so, you have availed undue exemption total amount of so and so and for the year 2007-8. Moreover, you have exported goods worth so and so outside the territory of India during the period 7-8 on strength of H form only under section 92 of the VAT Act within the scope of section 5 of the CST Act. But
So your thing is that this is in violation of section 39.
39. Before that, Lordship, in the third paragraph, fourth line, it is already marked that I have already been assessed in the year 2009. 23/4/2009. So now they have come up for reassessment under section 36. Subsequently, SOCO's notice, which is annexure 1. Another SOCO's notice is annexure 2, page 16, which is for levy of penalty for not filing of audit reports. They insist to levy penalty under section 62 of the VAT Act. Annexure 3 on 7/10/2015.
Your
I
reply.
filed my SOCO's reply. Down below, it is the receiving of the 7/10/2015. Is done on the same day.
Next is that
Page
62.
19 is the second proposed reply against 62 for levy of penalty against audit report, which is also filed on 7/10/2015.
This is the demand notice.
Then the demand notice comes on the 7/10/2015 itself. That means they have not considered my SOCO's reply and directly handed over me with the assessment order. This is the time I have specifically made the allegation in my paragraph. The day when I went to submit
And the
my SOCO's
penalty is
reply-
at page 23.
Yes, Lordship.
So
That's the thing.
give me 39. Section 39. This is 2006-7.
VAT Act, Lordship.
Assam better. A mota kitab to What does section 39 is with regard to the time frames?
Time frame of 5 years from
5
the end
years.
of the relevant assessment year.
That's the issue.
That's the basic issue.
Yes.
Lordship,
You have not done it under 9(2). Red with 42. This is under 39. So 39 assessment is over.
36.
Assessment
they
is
have done assessment 36, which is over as per 39 within 5 years.
5 years. This is an assessment under 36. 1 to what?
Under section 36, Lordship, which speaks about audit assessments.
Auditors, okay. So they wanted to do it under section 36.
36. It is done under 36, but
Okay.
in the year 2015.
Okay, fine. That is after beyond 5 years.
Beyond 5 years, it's 8 years, 6 months. Lordship may come to section 39.
I've
Specifically,
got it, 5 years, specific. All the above foregoing provisions, specific.
yes, that's the only case, Lordship. Without jurisdiction.
So, Mr. Chaudhary, the case is on a very narrow compass. We are not going into the merits. So on the application of 36 and 39, you can do it under 36, read with 39, provided the same is done within 5 years. Eight years come in under 42.
Lordship, 40
40 subsection for her. So where is that material?
I do the so-called.
Hmm.
On the same, issue,
No. See, in my humble submission,
petition.
No, no. If this is a technicality, we will have to interfere.
Lordship, because his specific allegation is
Fine, but 39 can always, it's a question of law. 39
Oh, yes,
we can examine.
Lordship.
Is there an interim order operating?
Yes, Lordship.
Okay. Heard Mr. A. Todi, learned counsel for the petitioner at length. So and so. Also heard Mr. B. Chaudhary. As prayed for by the learned counsel for the parties, raised it to list this matter. I'll pass anything to add?
Lordship, only will produce the record, Lordship.
No, you give me a written argument, incorporate everything there. On 1/9/2025. Also, the petitioners are at liberty, parties are at liberty to bring on record their respective written arguments. Just tell me if the matter can be taken out of the purview of 39. If it can be, fine. You also just highlight that, that's all. Aruki, is it answer? 27.
In this matter, Lordship, we are led by
A prayer is made on behalf of Mr. D. Das, learned senior counsel, for adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. So, prayer is not objected to by Mr. R. Borpujari, learned standing counsel, revenue. Also, raised it to list this matter again on. Not the 2 last weeks after that. 4/9/2025 for hearing. Oh, that is always there. If this court is there, make it anytime you want. Other court, I cannot. I'll not. Other court, I'll not. This court, it comes to all. If there is a matter in the bottom of the list also, urgency is there, please come and make a mention. No issue. You come and make a mention, no problem. Time being the person.
there is an interim loss.
Interim order, if any, to continue. Interim order passed to continue till the next date of listing.
That's loss.
10 to 12 from finance department. Forwarded the request to the finance.
Mr. Barpujari, this is with regard to compensation, land compensation. Everything is done. Now the matter went to the government, so naturally they'll have to have a concurrence from you. They have forwarded the file to you on 2/8/25. Till now, it is pending. She'll give you the details. Mr. R. Bappuchari, Learned Standing Council, Finance Department, is requested by this court to receive instructions as to the stage wherein the proposal submitted by the Water Resources Department for release of compensation to the petitioners in the above noted case is pending. Also, Ms. R.M. Deka, Learned Standing Council, Water Resources Department shall furnish to Mr. Bappuchari the required materials. Also, registry to list this matter again on 3/9/2025, reflecting the name of Mr. R. Bappuchari, Standing Council, Finance Department in the cost list. Aru ki ba ase? Ei mane amar time nei.
Case of the petitioners where there were two gates. One gate, my lord, they have.
Okay, fine. We got it. But there is nobody. Duta was at 2 o'clock. Any problem? No problem. 2 o'clock.
Or if your lordship fixes on Tuesday, that is also fair.
To this 2 weeks, I cannot. I cannot touch. There is awfully full.
Then, my lord, thereafter.
On the prayer of Mr. P.K. Roy Chaudhary, Learned Council for the petitioner, registry to list this matter again on 9/9/2025.
Sorry, my lord, that I could not be present. Here.
No, it's not. Yeah. Just go through it.
I've gone through it, my lord.
Ah.
Perhaps his remedy lies in the section 147 of regulations, Code of Revenue, because the of cancellation of pata by the DC himself, my lord.
That you don't get it. That's a larger issue than that.
Otherwise, I can.
There is a, I just want to know whether the land that he is claiming, because there is a title suit.
Yes.
Therein, it is said that the land claimed by the DFO and the land claimed by him in his suit is one and the same. Forget whether that suit can be implemented. Let's forget that. This court said, okay, fine. If that land is within the forest area, gone. Now, I only want to know, you have the Deputy Commissioner in the joint verification has identified a particular plot of land. Whether that plot of land, in terms of the original notification of that, it comes within the, that much only. When? Tomorrow? Or tomorrow is holiday?
Wednesday or Thursday?
After a week, my lord, it might be long. I have to, my lord, add something, lordship. My lord,
yeah, just getting that clarified. Mr. Mohammed, this is not to your prejudice.
Yes, lord.
I'll not decide without hearing you. You have beautifully placed the matter. You have stopped me. I'm asking this. That's it. Heard Mr. M.H. Ahmed, Learned Council for the petitioner, and Mr. D. Gogoi, Learned Council, appearing for the Forest Department. Mr. Gogoi submits that he would complete his instructions in the matter, more particularly with regard to the issue as to whether the land identified by the petitioner to have been possessed, to have been under his possession earlier, falls within the notified boundary of the reserve forest in question or not. They said instruction be placed before this court by Mr. D. Gogoi in writing from a competent authority of the Forest Department, along with the coordinates as set out in the original notification. Full stop. Registry to list this matter again on Mr. Ahmed, when?
After a week, lordship.
We'll have it on 1st, 1/9/2025. 1/9/2025. Let's see if it is, we can find that the matter is material, it's not there outside the forest. And if it has gone inside the forest and you had a right over that land, let's see how we can compensate.
I'll also bring some documents on record saying
please do.
The land is.
Please do so. We are not in a rush. Please do so.
Yes.
We want to be doubly sure that yes, what we are saying, what the Deputy Commissioner has said is correct. Thereafter, leave.
Any other pattas, dags are also there. The lands have been
Also, further, Mr. D. Gogoi shall also receive instruction as to whether The allegation of the petitioner that while he was ousted from the land held by him, comma, with the same vicinity of the persons in the adjacent plot of the property were not so required to vacate the lands. No. In the forest, you say the land is in the forest now. Oh, Mr. Gogoi, the land is in the forest. He says that beyond his lands also there are people living. I want a clarification on that.
I have to clarify one thing. RF.
We'll ask him to go, but you clarified that. In view of the above discussions and the disputes raised by the by the respondents having been concluded by this court to be without any substance, this court directs the respondent authorities to, more particularly, respond number 1, 2, and 4 herein to release to the petitioner his area contractual dues of rupees so and so within 45 days from the date of receipt of a certified copy of this order. As the petitioner has submitted that he would not be claiming any interest for the delay occasioning in releasing to him his admitted contractual dues, this court refrains from passing any order attaching interest to the amount due to the petitioner. However, it is provided that in the event the amount of so and so is not released to the petitioner herein within a period of 45 days from the date of receipt of a certified copy of this order, the said amount would entail an interest at the rate of 6% from the date of disposal of the present petition. But the order would be uploaded only on Monday because they are leaving today. Will not force them. There's some corrections. Monday you will get the order. Monday Ratiba to me to upload. It will move promote it. Can inform Mr. Bhuya, he is around or he is out? Oh. Mr.
My lord.
Taranya,
My lord.
today there is a change of guard. My stenos are leaving. I'm getting a new set.
My lord.
I don't want to trouble them today.
My lord.
Because they are from Arunachal. I've been
My
brought
lord,
here,
my
so they are going back.
My lord.
So we'll have it on 19th and I'll pass the order in the meantime. Now, you need not be here. We have already heard you. Solely for delivery of orders. So, the present matter was listed for delivery of orders. However, on account of due to paucity of time, the delivery of orders is the learned counsels for the parties have brought on record their respective written arguments. Also, same is taken on record. Also, the delivery of order is deferred to 19/8/2025. Also, registered to list this matter again on 19/8/2025 for delivery of orders. I'll thank you.
Law.
I'm not.